positive measures and even incur extra hardship while allowing all persons to participate in school life and enjoy all their rights equally and, in essence, accommodate all learners' needs. For the learner to be said he or she fully enjoyed the right to education, all the learners must be accommodated. In other words, education must be available to all learners. Again, in line with the four features of the right to education: availability for the purposes of right to basic education is defined as functional educational institution, or that the functional educational institution must be available to all learners. And this entails the provisions of buildings, sanitation facilities for both sexes, teaching material, libraries, computer facilities, and access to the internet. Of course, there is an issue with the fact that the sanitation facilities must be for both sexes. At this day and age, that should be accommodative of all, regardless of their sexual orientation. In other words, if facilities must be built for those who will not be falling into either male and female, then that must be done. And the failure to meet these requirements will be discriminatory and therefore fall short of the dictates of Section 29 of the Constitution. And maybe the last point on this scenario is the fact that the transformative nature of our Constitution demands that whatever right that is supposed to accrue to anyone, it should take into consideration the developments. It should take into consideration the circumstances of the person concerned, including the history of that. If in the past, people with a different sexual orientation from those that were considered acceptable, then that's not longer the position in 2022. And the Constitution demands that those who are left behind must be accommodated. And in conclusion, the right to basic education is, of course, subject to Section 36 of the Constitution. In other words, the limitations clause are applicable. But when applying the limitation clause, one needs to look into, or the question should rather be whether the learner's appearance leads to a material and substantial disruption in schools' operation, activities, or the rights of others. And this right can be limited as the disruption of school is unacceptable. In other words, when you apply Section 36, you look into the purpose of education as well as purpose of uniform, and make sure that you look into that substantively, not as a matter of form, that if a person is wearing something that may, in terms of appearance, may not be in line with what is required by whatever policy or guidelines. Instead, you shouldn't be looking into that. Instead, you should be looking into the right substantively. In other words, whether will it cause disruption. And that is my last point. I must apologize. I'm sure that I've gone beyond my time. Thank you so much for listening. I think some of the issues that I would have covered, and I'll address them during the question session. Thank you so much.
Thank you so much, Dr. Ndlovu and Advocate Stacey. Again, this was very informative and creates such a rich baseline from where we need to move towards. And it's actually very interesting how both of you also pose questions, because it's as if for the first time we are grappling with this concept of school uniform and how it contributes to access to education, and also in terms of the four elements that you've pertinently pointed out. So I'm going to give you over to Commissioner Gaum now for the first round of comments and questions, and you will decide between the two of you who will be best suited to answer the questions or the comments posed. So Advocate Gaum, over to you.
Yes, thank you very much. I don't have a specific question. I just want to really thank you for your detailed presentation, giving us a very proper legal perspective. So thank you very much for that. I give over to Dr. Carter to pose questions.
Thank you, Commissioner. I maybe have two questions based on the presentation this morning. Let me just check that I've got. There we go. I've got two questions, Advocate Stacey and Dr. Ndlovu. I think, Dr. Ndlovu, you indicated this morning or during your presentation that yes, there are case law available. And we have the laws available in terms of, let's say, Papuda or the Constitution, etc. And you made a comment to say you don't know whether schools are ignorant in respect of applying these basic principles. And I think you mentioned whether they are not aware of case law specifically. Well, what we've heard here today is from our first presentation into the Gender Commission, also outlining concerns that they have in cases they've dealt with. You've highlighted a few cases yourselves. Do you think we need oversight in respect of the implementation of what you've clearly outlined at school level? And do you think that currently the SGBs who has the mandate in terms of the formulation and the implementation of these codes of conduct are being guided? And I don't want to use the word guide because it seems like we've done a lot of guidance and recommendations and encouragement, and we are still sitting with issues. How many years into democracy in respect of diversity and encouraging diversity? So, do you think we might need more pertinent oversight from the department side in respect of the implementation of what we know is out there in terms of case law or jurisprudence, etc.? So that's my first question. My second one relates to what we discussed this morning with Prof. In respect of the decolonization of education, and then basically uniforms, because we've closely related the wearing of uniforms to access to education now. Because it seems like the concept of the wearing of these uniforms is almost, again, I'm going to make the comment that it is very much aligned to a military approach, where discipline is equated to uniformity. And it comes across that we have aligned ourselves to say that if children look the same and wear the same, that discipline is possibly easier achievable. Now, I think this morning Prof even indicated that there are different schools of thought already on this. There's no alignment to say that the research says X, Y, Z. And I'm going to throw it back to the abolishment of corporal punishment within school structures. Are we not now far enough into the acknowledgement of inherent dignity of children, or the participation of children, or the immediately enforceable right of access to education of children, to allow for this discussion to take place, to say Let's refer to Section 36, as Advocate has pointed out, but let's then look at a less restrictive means of achieving discipline, which is what Section 36 calls for us to do. So it's the second one is more a comment, but I'd like to hear your thoughts on is it not time for us to engage then further with Section 36? What is the less restrictive means to move towards what we have outlined possibly now? And I'm going to say the pseudo reasons, because I don't believe in what we've heard here today, that there's in fact enough evidence and research that this is in fact the only way of us controlling discipline within the school environment. It's not from what we've heard here today, but luckily we're still going to be engaging for the next 2 days. So is there now almost a duty on us to re-engage Section 36? Because there should be, in my view, a less restrictive means to achieve the same outcome when we look at access to education, coupled with dignity, coupled with self-expression, coupled with gender, non-discrimination, culture and religion, to achieve the same means. So I'd just like to hear your comments on those two specific areas. The one would be the oversight that is possibly required, and the second in terms of this concept of discipline and whether it's not possible for us to re-engage on a less restrictive means. Thank you very much, Dr. Ndlovu and Advocate. Over to you.
Thank you so much, Doc, for those comments and for the question. Let me start with oversight. Let me say that indeed there's need for oversight, and I was expecting this question because you asked it in the morning to Prof. Because to me, I think where we are lacking perhaps maybe is that there isn't enough monitoring and evaluation by the department. That must be playing a very active role. I understand that you know the Human Rights Commission plays an active role, the Gender Commission, etc. But from the very implementers of the law in this particular context, there need to be constant monitoring and evaluation as to what is working, what is not working, what are the international best accepted practices, what is comparative law saying, how can we improve. But all this must be channeled as to what Advocate was saying, to the purpose of education. What do we want to achieve at the end of the day, and what we are saying about less restrictive means to ensure discipline. So our main energy must be channeled as to what kind of an education system do we need, what kind of a citizen are we building through the education system, are we accessing and removing all barriers, all of them, that may affect or limit a learner unfairly so to access education, because this discussion, I don't want us to trivialize it, but it becomes difficult even in the context of rural schools. You can imagine if you go down to the deep rural schools, how do they accommodate, gender non-conforming learners, for instance, because the parents, the schools, and the community at large, they are still conservative in nature, So you still have all these challenges, and then there's a learner who's caught in the midst of all this, and then in the process become excluded, or bullied, or whatever the case may be, without any sort of recourse. It's much easier in urban schools and so forth, because then there's a lot of information is being shared, there's a lot of exposure, but it becomes difficult in the remote areas, because the challenge becomes even much bigger, because you've got this whole system of conservatism, you've got this whole system of that these things must be done this way, and there's nothing that is taking place. So there is indeed a need for oversight, therefore, by the department, from the national to the provincial, all the way to the schools. And now maybe Advocate will add onto that, but also maybe on this issue of oversight, I want to say something that came into mind. To say, currently, you see the Commission for Gender, for instance, they are drafting a concept note. You are doing this inquiry. Civil society organizations are working on the other side. So I think there's need for us to come together at one point to say, okay, look, what you guys say, what are submissions, what are our submissions from the academia or from this or from the legal perspective? Let's sit, let's assist the department to draft guidelines that are accommodative for all of them. So now the ball then becomes in the in the court of the educators or in the department, then to come forward, create a stakeholder meeting, call everyone, have a draft, send it out for comment, let it come back, so that at least what we have at the end of the day is inclusive of almost everyone, because what is being done on this side might not be done by the other side. So, but now if you bring all the parties together, then you may then see that you may achieve at the end of the day like proper, gender-free or flexible rather, sort of guidelines that are going to assist schools. And on top of that, go down to the communities and then sensitize them about this, especially the educators in the school communities. And also maybe there must be a link between the curriculum that is taught to educators, because they are one of the key players here. Because what are educators taught? Are they taught about, during their education policy and learning management course or module, are they taught to accommodate all learners? Because some of them still go to school with all this conservative nature and therefore may discriminate directly on learners that are not, ridicule them and those sort of things. So it goes all the way deep to say even the curriculum itself, at university level, at tertiary level, at college level, must be accommodative enough to teach and train this person to say this is how you treat this person, this is how you address these issues, etc. And on the issue of decolonization, maybe let me say that I do agree with you that at some point we might have to, I'm glad that this conversation is ongoing to say we need to come maybe to terms to say that there are still elements that we need to decolonize within the education system as a whole. And also maybe something that I've got problems with, and I think Doc will agree because I'm told your PhD is on children's rights. There's something on Article 31 of the African Charter, and for because of time I didn't talk about it. It was about the duties of a child in the African context. And to me, it creates a problem because it makes a duty to respect elders, educators, and community leaders. And it defeats the whole purpose of freedom of expression that we are saying all over again and again, because a child, is told that you must listen, you must not say anything, So whatever guidelines that we have, we need to ensure that discussions involve children, of course, depending as to their evolving capacity, etc. Because it is fruitless, to me, and useless that we are here, and then the actual victims of these may not participate in the discussion. So, so we need to involve them all the time to say what in their perspective, in their shoes, what do they think? How do they feel like? So I think it will contribute to the mantra of decolonizing even our own minds, decolonizing the curriculum, and the whole system as a whole. Thank you so much. I think Advocate will then add from there.
Starting with the first question of oversight. Oversight and monitoring, yes, of course, they can play a role, but for me, it will be there will be a question of sustainability in terms of oversight and monitoring, because there should be resources allocated to that, and in the past that has been the challenge. For me, if government can bring clarity on the regulatory instruments, then that can play a significant role, because much as we spoke about all these cases, and these cases are in the public space and they should be known, but maybe it's a little bit unreasonable to expect all the SGBs to know the case law that are current, when in actual fact you find out some of even these guidelines are outdated. So my point would be that there should be focus on modernizing the legislative instruments, the first point. And secondly, reorientating all the stakeholders. Reorientating all the stakeholders, simply because if you can reorientate them and bring them on board, I'm sure then you won't have to worry about oversight and monitoring, because they will be the ones who are behind ensuring that there's been compliance with all the regulatory instruments. So that will be my contribution in relation to orientation. With regard to uniform, yes, I think a serious engagement is really needed. And of course, that's what, after all, democracy is all about. It's about constant engagement, and the context and time is always relevant to almost everything. What was a good practice in about 5, 10 years ago, I'm sure by now it's something that needs to be revisited and see if it's still as functional as it was when it was in place. For me, with uniform, what is more appealing um, is the issue of making education accessible rather than the concept of discipline. I notice with all the documents that talks about a uniform, they always come up with this concept of discipline, which for me, it's really outdated. It's really outdated. Hence I'm saying what is more appealing is accessibility. But as I said, debate and engagement, it's necessary. Thank you so much.
Thank you so much, Advocate and Doctor. I think Commissioner wishes to make a comment. Commissioner?
Yes, I just want to make a comment and hear what your response would be to that, because sitting here, I'm even thinking, that guidelines as such is also already a problem. Because if it's only guidelines, it can be followed or cannot be followed. The whole matter of oversight, yes, of course, there needs to be a degree of oversight, but I mean, the Commission has, for example, written to all the MECs, and I think the National Minister as well, asking them to do an audit, of the codes of conduct of schools, and then to ensure that these are human rights compliant. I don't think much has happened in that respect at all, and I'm not, it's a bit difficult for us, for example, to monitor exercise like that. So we've also met with the national department, and they are quite keen to work together with us to develop a model human rights friendly code of conduct for schools, which I think is a worthwhile and a good project. But I am wondering whether, there shouldn't, on these issues that is the focus of this inquiry, whether there shouldn't be prescriptive provisions that need to be included in codes of conduct. In other words, that the department says, look, when you deal with matters concerning uniform and concerning hair and cultural expression and spiritual expression and so on, these are the provisions that you need to have in your code of conduct. I'm wondering if that wouldn't be the best, given that to make it a sort of a voluntary process or guidelines or whatever the case may be, that might take us forever to make sure that all the codes of conduct in the country of schools are actually compliant in respect of this particular matter. Your comment, please.
Maybe let me start. Thank you so much, Commissioner Kamp, for that. I think I agree. Maybe at some point we should have prescriptive provisions, sort of a model law that is going to give guidelines. Like you're correctly saying that the guidelines are not binding, so it is at the discretion of the SGB or the authorities, school authorities, whether to implement them or not. So that may be problematic because it now depends as to the person that is interpreting what is before them. So maybe perhaps at the national level, at least, it might be important to have at least uniform and prescriptive guides. And if then that are not stated, that are going to be changed, like what advocate is saying to us, to say they must be, they must continue to transform them, or revise them rather to, of course, to adapt, of course, to the needs of the times and to the fast changing society that we live in. So I do agree on that note. I'm not so sure if advocate wants to add, but yeah.
No. I share the same sentiments insofar as this question is concerned. If maybe you can come up with something that would be will have more teeth compared to the current guidelines, and more especially given the fact that the governments, I think it's something that is a kind of a practice that they take time to do things. So it would be good if they can come up with something that would be uh, more authoritative than these guides. Thank you so much.
Thank you very much.
Mr. Mpondo, do you have any questions for the participants? I'm handing you over to Mr. Mpondo.
Thank you, Dr. Ndlovu and Advocate Seti for your presentation. As I'm sitting here, I'm trying to probe this ignorance, especially by the private school, and I'm asking myself, is there anything called waiving of rights, especially in as far as the right to education is concerned? The reason I'm asking this question is because if I take my daughter to a Christian school, knowing very well that we don't conform to that, am I waiving my daughter's right and am agreeing to be bound by the rules of the school? Because nowadays it seems to be a challenge if one considers that there is still a case which is going to the Constitutional Court on Isipandla. I'm sure it's a matter that happens in Western Cape High Court and now is leading up to the Constitutional Court. What is your view or your response to that? Thank you.
Maybe.
You can go ahead, Advocate, please.
Oh no, proceed, dog.
Oh, all right. I just took into account that maybe since I started responding, maybe I should respond. I would say it's a very complex issue. It's not something that is very easy to respond to. But maybe let me say this, that earlier I said to us to say that our yardstick should be the Constitution. So even the Constitution of a private school, that subscribe to Christian beliefs, for instance, should by all means find it necessary to have reasonable accommodation or to accommodate certain learners, especially taking into account the shortage of schools, the growing number of learners, and so forth. Because should we permit such, discrimination, I would want to say waive rights. It will make it problematic to a large extent because it will mean that certain learners cannot be allowed to attend certain schools just because of that. I think at some point there's a number of cases that have come before our courts, especially on the issue of language policy. In Kampala, for instance, So, and what the court said, in those thinking about schools, in a specific department, they have a role to play, but the schools need to find ways to ensure that they accommodate all learners. It is accustomed to or wish to be taught. Of course, it will include the issue of resources. Thank you so much.
I share the same sentiments. There shouldn't be. You can't have a situation where you waive, in my view, your rights when, in actual fact, you are exercising your rights that are in line with what is stated in the Constitution. So, to a large extent, it will be the question of these two competing interests, which is that of right for the owners of the school concerned to create a school that will be in line with their values. But the simple fact that they admitted a child who doesn't conform to that, for me, then they are under obligation to accommodate the person concerned. But it would be a different situation if it's admissions policy that says no, we can't admit anyone who is not belonging to the Christian community. Then the simple fact that they admitted the learner, then for me it should, without the learners implying that he or she will be complying or behaving or practicing the Christian values. So that for me should force the school to accommodate the learner consent. That would be my take.
Maybe just to add to what Advocate is saying now, and I think this discussion is very important because, most Christian schools or most religious schools are going to find it very hard to accommodate gender non-conforming learners. So I think maybe wider debates or discussions are needed even on this, because we do not find ourselves with schools that reject learners, like what Advocate is saying, if the admission policy says so. But sometimes what we see is that these policies are not expressly, said out or written down, but sometimes they might be hidden, through customary practices to say a certain learner of this kind of personality is not accepted in this particular school, which will be very problematic because it unjustifiably limits the right to education of that particular learner. So I think debates are really needed and engagements, with all stakeholders on this issue. Thank you.
Yeah, I think this is a very interesting one and a very important matter. Now, let's say, for example, you have a Christian school with an admissions policy that says that if you are gender non-conforming, you will not be allowed into this school. Would that be constitutional? Secondly, would it be constitutional for a school to actually require a learner to indicate in terms of gender, whether that person is male, female, or gender non-conforming, or whatever the case may be? I'm not so sure about that as well. Maybe your comments on that. And then let's say someone has been admitted because the admissions policy doesn't talk to those issues. It only requires, let's say, the person to be a Christian. And now this learner is admitted, but is indeed also gender non-conforming. What would be the position of that learner and the rights concerning that learner? And maybe a last issue is this whole matter of, it's even more complicated than that, because, there are also Christians with various different views in terms of these matters. So what Christianity is going to be applicable when a school decides on a matter of on these issues pertaining to gender non-conforming learners and so on.
It's a very complex matter. It's a very complex matter, but for me, I would be leaning towards using the constitution as the yardstick. If the constitutional demands are that the person must be, so I beg your pardon, there should be diversity in terms of religion, and all those must be accommodated in public institutions. Not only in public institutions, of course, that should be, in my view, applicable also, because it's the law of the country. That should be applicable even to private schools. There are very interesting cases relating to the exclusion of it was students by trust that were established a number of years back during the apartheid time, where the trustee would say specifically that these funds must be for boys of this origin, for instance, Irish origin, and the courts in those matters, they said in actual fact, no, that should be changed. Though ordinarily the freedom of testation should be, because they were established in line with the wills of the deceased who donated those monies. Though ordinarily the freedom of testation should be protected by courts, but the simple fact that those the terms of those trusts are no longer in line with the prevailing constitutional dispensation, then that should be changed. And indeed, they were changed. As my mind serves me well, there were funds that were available to students in the University of Natal as well as Cape Town. So I think for me that's a very simple approach by courts that should also be adopted even in circumstances such as these ones. Because as you correctly pointed out, even if one can say you are a Christian, then I beg your pardon, I'm a Christian. Those who established the schools are Christian. In terms of how we deal with issues would be different. Some of them would be say gender non-conforming, and there is something wrong with them. The others would be saying something else. So to avoid those complex situations, the simple approach for me would be leaning towards the Constitution, which should be applicable to everyone. And of course, as I said, it would be a matter of balancing the competing interest. But for me, what would appear to be more reasonable is that of saying the school should be accommodative to everyone, regardless of their religion. Thank you so much.
Last question from my side. Let's say you have a private Christian school, and this school would require boys to have short hair. Not girls, obviously, but boys should have short hair. That would most surely be unconstitutional, wouldn't it? As I mean, it cannot even be said that it is an intrinsic element of Christianity that boys wear short hair.
Advocate Sethi or Dr. Ndlovu, would you mind to respond?
Okay, I got cut, so I thought advocate was on the floor. Anyway, thanks so much again, Commissioner, for that. I think on the face of the prima facie speaking need to be discriminatory, unless of course there is a very reasonable reason to justify it as to why is that. But otherwise, if there's no logical reasoning whatsoever or any rational perhaps approach behind that, just because it is based on Christian beliefs, then I for one will have a problem with that, and it will be very problematic. Because then now you are sort of aligning the physical appearance of a person based on certain values that you think are correct. Because even within the Christians themselves, there's a lot of differences. So there's no uniformity as to what is correct and what is wrong. So hence, perhaps we must lean more towards the dictates of the Constitution and what is maybe required of us or school governing bodies, even religious schools, in order to ensure that the education system is as inclusive as possible to everyone. Maybe perhaps just to add also is to say maybe that is when we may need, just that due to time I didn't touch on that slide, wherein there are clear guidelines, like it was said in the case of delay, for learners to apply for exemptions So maybe if that is created, wherein there are maybe prescriptive guidelines by the the national department, at least at that highest level, to say, okay, these are the guidelines a learner in a religious school can apply for exemptions, and this is the procedure for it. And when there's a dispute, this is how it should be solved. Then it should be better. Otherwise, without such parameters, it might be difficult to regulate that, and we may see some of it or hidden, best practices that offense unfairly so on the dignity, quality and expression of learners that may find themselves in certain spaces that are different from what they conform to or what their convictions are.
Thank you, Dr. Ndlovu. Just on that, maybe touching on that, I would find that to place another restriction on a specific person to have to apply to exercise a constitutional right, and that you need to apply and be given permission for self-expression and for the right, your dignity right to be adhered to, and your right to equality to be adhered to. So what would your response be to that? If we have a male child or a child who chooses to wear longer hair, do you think it would be fair and possibly impose a burden on that child to have to apply to actually exercise these rights which should be inherent to that child?
Yeah, first my response would be that I criticize the Pele judgment so much in that regard, and I want to say that that should be the worst case scenario, to say they failed to do everything, but to create a culture of tolerance, let them at least apply. But again, it's subject to the learner to a process that is going to affect their mental ability. That whole process is traumatizing for a learner in question, whereas other learners are not, are required to do the same. They can freely express themselves. So that would be the worst case scenario in my view. But otherwise, it should be the standard, basic norm that everyone at least is allowed, prima facie speaking, to freely express themselves without having to be taken through all this process. Because even court processes, all these hearings, they've got a lot to play in the life of a learner, and a learner might not recover out of all the traumatic experiences they were taken through, or even to say you have to apply for these and to do that. So I knew that I'm opening a sort of gateway for question in that regard. But it would be a worst case scenario wherein the school says, okay, let's come up to the table now, let's discuss the issue involved. So yeah, but otherwise they should be allowed to express without applying, of course.
All right, thank you so much, Dr. Ndlovu, Advocate Seti. I think it was a very rich discussion and a fruitful discussion. I think a lot of the points you've made we can still build on, and it's actually an exciting journey that we can embark on together. Just as a footnote to give you an indication, I think Dr. Ndlovu, you mentioned, are we hearing from children? Are we actually engaging what we would call the alleged, I'm saying alleged because we're still busy in the process, alleged victims of these practices? And I can confirm that we will be hearing from the Congress of South African Students tomorrow. And we've also invited victims of these practices as well. So we hope to adhere to our duty in terms of Section 10 of the Children's Act to encourage child participation. So thank you for highlighting that. That is definitely also something very important for this inquiry. So without further ado then, thank you very much for coming, and for all colleagues also tuned in currently, we will be taking a quick lunch break, Zuki, until it is now, let's say it's 5 to 1, an hour. Okay, so maybe we will be reconvening here 1:45 to make sure that our technicalities are in order, and then we will reconnect 5 to 2, and we will then be continuing with our inquiry. Thank you so much, everyone.